arbitration has gone below the earth, then it comes to the earth level, that is section 9 suit, equivalent to that. And then you have section 96 equivalent to section 37. So my suggestion here is, with regard to arbitration proceedings, my suggestion is, let us have a pre-arbitration mediation. A pre-arbitration mediation should be at the most appropriate time. I would say even before the claim statement is filed. Let the arbitral tribunal, either sole or a tribunal, assemble. Let them have their dates, the procedural dates, case management dates, date of filing, claim petition, etc., everything put in place. But they must send the parties to mediation first. In this regard, my submission is that we have a Bangalore mediation arbitration center. I'm sure in other places also there are the High Court controlled or supervised arbitration centers, that or in any other place, to have a panel of mediators and arbitrators trained as mediators to mediate an arbitration dispute. Now, mediation is an alternative to arbitration, though arbitration is an alternative to a court adjudication. So we have to give the importance that mediation has at the end of the day. And I would submit that Justice Arade was there in the morning, that we could have a coordination wherein we will empanel our mediators suitable for the disputes which come up for arbitration before the arbitration center, and have arbitrators to be mediators because they are familiar with the branch of law, etc. Instead of going for an arbitration proceeding, first mediate the dispute there, and then if all that fails, go for arbitration. Because if there is a mediation and a settlement, that could be taken up as a Section 30 settlement under the Arbitration Act. There could be only one sitting by the arbitrators, unfortunately only one, so that they could sign the arbitral award. And then it is only for compliance, no Section 34, no Section 37, no Article 136. Thank you. The other problem area and an achievement, I would say first the achievement is the parliamentary recognition of mediation of commercial disputes under Section 12A of the Commercial Courts Act. There is an amendment made in the year 2018, and it is necessary that there is a pre-litigation mediation or a pre-institution mediation. That is a very noble idea, a welcome step. But I would there again say, when there is a legislative achievement, there is a corresponding implementation challenge. It says, unless there is an urgent interim relief, pre-institution mediation is a compulsory step must be taken by the parties. The plaintiff must apply. It is very easy to negate that provision by filing an interim application, howsoever frivolous it may be. Then they will say there is an interim application, therefore mediation before filing of the suit doesn't arise. But if in the court, in the suit, the trial court thinks that there is no interim relief to be granted, then what happens? The law is silent. Whether the matter could go back for a pre-institution mediation or it should continue as a suit. The law is silent there. Therefore, we need to think of some mechanism or some rules to be made so that the pre-institution mediation is not nullified by filing an interim relief application in a suit. The second aspect is, there will be a question as to whether it is a commercial litigation itself, whether it's a commercial dispute. Of course, now it has come down from rupees 1 crore to rupees 3 lakhs. That, in my submission, is a welcome move, because Then the question of what is the value of the dispute, specified value, it is not a commercial dispute, such questions will be minimized. But even then, if the defendant in a pre-institution mediation takes up a contention that it is not a commercial dispute, then what does the mediator do? The law is silent on that aspect. This is again a challenge. Then I would like to also speak about the latest convention which has come about, that is the United Nations Convention on International Settlements Agreements resulting from mediation, which is known as the Singapore Convention on Mediation. This is only for international commercial disputes. This is again a pre-arbitration mediation proceeding. And if there is a settlement of a dispute, then it could be enforced in the states or the nations who have signed the convention. But it is, though it is a legislative or a recognition in law of mediation vis-a-vis international commercial disputes, the challenge is its implementation as far as India is concerned. How far or to what extent the convention articles will be implemented by way of a domestic law, by a parliamentary legislation under Article 253 of the Constitution, where an international convention can be made into a domestic law, we have to wait and see. But the emphasis is that there needs to be a pre-arbitration mediation. This is a recognition which has been fructified into an international convention. So if this recognition is there that ultimately it is mediation which is the solution, it is high time for us, the mediators, all administrators who are involved in mediation of disputes, and advocates, judges, all stakeholders to give the maximum impetus that it requires. Now coming to the other aspects of challenges to mediation, I will only list it out so that there is a discussion of it on the floor of this House. They are classified as these. One, lack of trained mediators. Training of mediators is very important. Not only the training itself, the content of the training, the schedule of training, etc. Two, lack of trainers. We want trained mediators, but we have no trainers. Lack of trainers. Three, lack of referrals. Our judges have to be convinced that there is a matter where there is an element of settlement and it needs to be mediated. We are having from our mediation center throughout the whole year in every district or a group of districts, we have a schedule for referring cases to mediation by the judges, but how far that is having an impact, I am not yet aware. 4, lack of infrastructure, particularly in the taluka and the district levels, where pre-institution mediation for commercial dispute is a compulsory thing. Then there is absence of suitable legislation. The question is, we have an Arbitration and Conciliation Act, we have a CPC, but we don't have a central or a parliamentary legislation on mediation. Question is whether we should have such a central legislation or it should be left to the states or through the mediation centers which are running under the control of the high courts to have norms or any kind of rules for mediation. Then the next challenge is resistance amongst basic actors and stakeholders, namely judges, lawyers, and litigants towards mediation. It requires no elaboration. The next is lack of mediation management. Time schedules, the way it is stretched, or the way it is abruptly concluded, Many a times we find we have made reference from the court, suddenly there is a conclusion of and we find that there is an element of settlement. Lack of adequate funds. Our mediators have just experienced that lack of adequate funds. The government must recognize, state governments must recognize that if mediation is going to be the order of the day, then adequate funds must be made available for the infrastructure, for payment of mediators, and generally for management of mediation centers. Then there is a mediation process itself has many challenges. Who is the mediator to mediate which dispute? It could be a commercial dispute, joint development agreement, HU of property, contract act, a tort claim. Then which mediator is going to be assigned to what subject? Should we have specialized mediators, specialization among mediators vis-a-vis the subjects or branches of law? Then the question of neutrality of mediators, the commitment to resolve the dispute, and the general conduct of mediators. These are all coming within the aspect of training. Therefore, while mediation is hailed and recognized as the most important or appropriate, because justice should be loud and clear and not soft and, Yes, yes. So therefore, even this, without this, I think I'm quite competent with the lung power. Finally, I would only end on a very secular note, though it is a quote from, not a quote, but a message from the Bhagavad Gita or the Mahabharata, that we who are in the legal fraternity, who are seeking justice for the litigant public, we are all warriors seeking justice. And our message is resolution of disputes in whatever level, authority, or position we may be. We want that there should be peace in society, and it looks as if now peace in society is guaranteed through mediation, a successful mediation, because the relationship is restored, the business relationship is restored, and there is a win-win situation. With these few words, I once again thank the organizers of the India Legal and the associate organizations for having invited me. My special thanks to Madam Rajshri Rai and her team for coming all the way from Mumbai to Bangalore, for inviting me to this conclave and giving me an opportunity to share a few of my thoughts. I would be waiting for your reactions and suggestions. Thank you, one and all. I thank our chairman and for our co-panelists for bearing with me.